A landmark ruling from the nation's highest court, the U.S. Supreme Court siding with Amish parents, affirming their right to raise and educate their children according to their faith. It's a decision reigniting the debate over parental rights, religious freedom, and the reach of government. Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our guest panelists that we have with us today. First, we have with us Mr. Todd McFarlane, General Counsel of the General Conference of the Seventh-day Adventist Church. We have Mr. Tim Schultz, who's the president of the First Amendment Partnership. We have Mr. Andre Wong, who's the general counsel of the North Pacific Union Conference of the Seventh-day Adventist Church. And we have with us Dr. Timothy Golden, professor of philosophy at Whitman College. Gentlemen, great having you here again. Looking forward to our dialogue. You know, the justices of the Supreme Court just recently reversed a decision by the Second Circuit that allowed the state of New York to force Amish parents to vaccinate their children. When the families asked for religious exemptions, they were denied and faced with penalties from the state directly violating their religious freedom and parental rights. The Supreme Court in Mahmoud held that as a parent, you have the legal right to opt your children out of lessons in public schools that substantially interfere with their religious rights. For religious reasons, the Amish educate their children in private schools and have done so for hundreds of years without vaccinations. And for over 50 years, New York accommodated their religious belief by granting religious exemptions from the state's school vaccination requirements. You know, Todd, what's a little interesting here, for 50 years, it's all good. But now all of a sudden, the state of New York decides to turn everything on its head as it relates to the Amish, and to tell them now that what we said before, we're no longer with that right now. You know, when we see these type of changes happening, is this really probably politics running amok? Or is it really, well, you know what, the health issues that are happening have to be focused on from a safety perspective? Or really is it just something where religion just doesn't have the muscle it used to? What are we looking at here, and why are these cases popping up even now?
Well, I think there's been a number of reasons. First of all, vaccine hesitancy and vaccine objections, which predated COVID, have played a role. So exemptions that you had that were rarely taken advantage of have been, quite frankly, just abused, right? So, for instance, California was one of the first states to get rid of its religious exemption back in 2015. One of the top parts of California to invoke their exemption was Marin County. Marin County has to be one of the least religious parts. You really think all those Silicon Valley families found God? No, they were abusing the vaccination. However, in this particular case, and New York is one of 3 other states that followed suit in revoking the religious exemption, there's no question, you can't probably think of 2 different parts of the country, Amish in New York and Marin County, California, right? And there's no question that these are sincere beliefs, that the Amish, hold themselves out separate from society. Interestingly, what the state of New York did here, they required it not just for public schools, but for all schools. So the small little Amish schools that only Amish attend, the state of New York was trying to come and tell them what to do in their little 1-grade schoolrooms. And you got to ask yourself, I don't know that when the state of New York passed this law, they had the Amish in mind and they were the ones they were particularly targeting, but they absolutely targeted them at their enforcement, right? If the state of New York had some common sense and said, you know what, we're just not going to go after the Amish, which, by the way, is probably the right decision most days of your life. If you're a government official, should I go after the Amish or not? Usually saying no is probably the right decision. But the Supreme Court has a practice called GVR. It's called grant, vacate, and remand. And that's where they take the case, they get rid of the opinion below, and then they tell the lower court, we want you to think about this again, but in light of usually a very recent decision. And in this particular case, they want them to reconsider in light of a case called, which we've talked about in this show before, called Mahmoud versus Taylor. And that was one that came out of Montgomery County, Maryland, where they got rid of a religious exemption and forced parents to expose their kids to LGBT content as young as first grade. So this is going back to the Second Circuit. Most courts of appeals, when they get a GVR like this, understand what they're saying and do the right thing. But if the Second Circuit doesn't do the right thing and allow the Amish to get this exemption, I think we'll likely see this case full blown at the Supreme Court.
Yeah, what the court did here is quietly significant. The court is really signaling that religious parenting rights have more constitutional weight than what they've been previously given, especially in the education context. So for decades, states like New York have allowed religious exemptions to school vaccine mandates, which recognized accommodation for insular communities like the Amish, who have structured their lives and their educational systems around their sincerely held beliefs. But then in 2019, New York changed course and put Amish families in this impossible situation: violate your religious convictions or face penalties for living consistently with your faith. So the lower courts have largely sided with the state, treating the vaccine mandate as neutral, but as Todd mentioned, Mahmoud, maybe shifting that landscape. So here the court emphasized really that the parents have a constitutional right to shield their children from state-imposed elements that substantially interfere with their religious formation, even in public schools, and that's a big deal because it reframes these cases not just as free exercise claims, but as parental rights cases with a religious dimension.
I guess I would say, Orlin, that I agree with everything both Andre and Todd have said. I would just add, though, this isn't an entirely new thing. You know, the case that is inevitably going to be cited as Supreme Court precedent in these cases is another Amish case called Wisconsin versus Yoder that goes back to 1972, in which the court, with only one dissenting vote, said that the compulsory education requirements in Wisconsin that they were trying to apply to the Amish were unconstitutional. And that was a more progressive court in 1972, right? The same court that basically a year later gave us Roe v. Wade. But they were saying that the Amish parents in 1972 didn't have to go along with the compulsory education laws of the state. So I think that's pretty important to note. This isn't entirely novel. And I think all of these cases are like taking a fresh look at the Yoder case and saying, yeah, if it was good enough in 1972, it's good enough for 2026.
And so I was also going to mention Wisconsin versus Yoder, and Todd mentioned the targeting and the enforcement of this, which brings to mind another case that was decided not long after Oregon versus Smith, and that's the city of Hialeah case down in Florida, where the Supreme Court unanimously held that the legislation that outlawed the slaughtering of animals, which was part of the religious ceremonies that were a part of the group's religious free exercise, the court said that legislation targeted them, right? And as a result, that legislation was declared unconstitutional. So I think there's some concerns, if not with targeting within the legislation, but certainly targeting in the enforcement of this legislation that's problematic. The other point I'd like to make is that from a public health standpoint, a lot of the concerns about infectious diseases and how they spread that would ordinarily justify compulsory vaccinations simply don't come into play with the Amish. This is a self-contained community that keeps itself intentionally away from the rest of us in society, and they have a certain way of life that is sort of insular, and they do things to themselves. So this idea that infectious diseases spread and there's a public health concern and the state may have a compelling interest in all of that, I think some of those concerns are not really pertinent here because of the nature of Amish communities. And beyond that, even if the state could show a compelling interest, they would have a difficult time figuring out what is the least restrictive means, right, to furthering that interest. So I think those are some of the points that are important to consider here.
Yeah. Hey, Orlin, I think just two add-ons to that. One is that the case that Dr. Golden cites, involving Hialeah, Florida, is known sometimes as the case around the Church of the Lukumi Babalu Eye. I would recommend people read it because it's a textbook case and where the government was targeting a religion but pretending not to. Formally, the text of the statute didn't target any religion, but the subtext was all about targeting. And I think that's a pretty important piece of this, that lots of times bureaucrats will have an idea like, well, we can't make exceptions even for the Amish. We have a rule. If you ever deal with bureaucracies, you sometimes understand where Franz Kafka was coming from and why we get the word Kafkaesque. There's just a life of their own that bureaucracies often take. And I think this is just classic case. If Kafka were alive today, he'd say, I'm with the Amish on this one. And this is a classic reason why bureaucracies run amok.
Orland, going off of what he's talking about as far as exemptions, one of the things that was talked about in the briefing, there is an exemption, right? There's a medical exemption, which means the state of New York is preferring and saying, well, medical exemptions, those are legitimate, but religious exemptions aren't. You can say, well, it's a medical, they have no choice. But that presupposes that religion also is a choice, right? That the conscience gets less protection than medical. It also point out, like, how do you handle the medical individuals, right? There's mechanisms the state could have that you say to do with the medical exemption, because even though you may have an adverse reaction to this, you still are unvaccinated.
Right.
And that medical reality exists. And so the state, this issue of like, is a medical exemption valid and does that require a religious one, is not one the Supreme Court has directly addressed, but often comes up in these kind of cases.
Well, Andre, the tricky part of all of this is that we always like to lean into precedent, but at some point, fresh looks on all activities are required, which is how precedent gets, changed from time to time. There's some laws that existed in the 1800s. I'm glad precedent got broken. So when do we get to a point where the fresh look on things is still just really something that probably is in the best interest of society?
Yeah, and the state of New York has a serious argument on this too, that vaccination laws exist to prevent outbreaks and to protect vulnerable populations. So the courts have historically given states broad authority in this area. So it's not a trivial government interest. It's one of the strongest that the state can make. But going to your point, what the Supreme Court seems to be saying here is even strong public health goals don't automatically override religious parenting rights without careful scrutiny, especially when less restrictive alternatives may exist, like exemptions that had been working for decades. So the big question for the Second Circuit now is can New York justify this policy under a more demanding standard, one that takes seriously both free exercise and parental authority?
Yeah, I'm going to have to let that be the last word on that. But, what's interesting is even going back to the Second Circuit is not exactly a circuit that spends a lot of time looking at religious issues. It spends more time looking at financial issues. So hopefully when this is all said and done, we'll find a balance that makes sense for all aspects of society. Coming up, a religious group finds themselves in court over a decision on leadership. Stick around to hear more right after this. When faith and government collide, the issues can be complex and consequential. Faith in Politics explores how religious conviction intersects with law, policy, and public life, offering depth, balance, and clarity with meaningful discussion and trusted insight. To see a bunch of our previous episodes, check us out at faithandpolitics.tv and subscribe to us on YouTube. There's a case that's called McRaney versus the North American Mission Board of the Southern Baptist Convention. Religious groups should be free to choose their leaders without being dragged into court. Yet a former Baptist leader, after losing his job over disagreements over the direction of a shared ministry, filed a lawsuit against the North American Mission Board, the Southern Baptist Convention's ministry, and was saying that they were focused on evangelism, and he thought he was as well. Well, recently we have lawyers that have filed friend of the court briefs urging an appeals court to protect the right of religious groups to make their own decisions free from government interference. But after more than 8 years in court, the Fifth Circuit ruled recently that civil courts may not meddle in disputes over internal religious leadership and ministry decisions. You know, Tim Golden, this has been a fight that's been going on for a long time, because what a lot of religious people don't get comfortable with is when you're granted exemptions, you are literally being authorized to discriminate. So this idea of how do you balance the power of having the ability to discriminate and ensure that it's really connected to your religious beliefs, because although you are quote unquote a religious organization, employment laws and other aspects of the laws still apply. But now we have this situation with this case, whereas a ministry leader is saying, well, they got rid of me because of some things that probably they should not have. Now I want the courts to get involved. It's getting a little messy, but it seems like I'm not sure there's an easy way around all of this.
Well, I think if the separation of church and state means anything, it means that the government should not be involved in telling religious leadership who their leaders should be, right? This reminds me of a case from about 13 or 14 years ago. Was unanimously decided by the Supreme Court, Hosanna Tabor Evangelical Lutheran Church, right? That case. And in that case, the court held unanimously. And it's difficult to get those 9 lawyers to agree on much of anything in the Supreme Court. But on this, they agreed that the ministerial exception is a strong exception to employment laws and anti-discrimination laws because of the First Amendment and the right of free exercise of religion. And also there are, frankly, I think, establishment clause concerns here, right? Because if you get the government involved in dictating to religious leadership who their leaders should be, it becomes a very serious problem. So for very strong First Amendment reasons, I think this case seems to me to fall squarely within the ministerial exception and within the precedent of the Hosanna Tabor case.
Yeah, and Orlin, I think that thinking of this as an exception is the wrong way to think about it.
Okay.
The supreme law of the United States is the Constitution. So employment law, the Constitution isn't an exception to employment law. It's the other way around. The Constitution is the highest law in the United States. And the laws that we make in various aspects of life are always subject to all provisions of the Constitution, right? We wouldn't say, if there were a law about how we treat the incarcerated, that being subject to the Fourth Amendment, restrictions against unreasonable searches and seizures, is some kind of exception to our laws about how we treat criminal suspects. So we'd say, no, the Constitution is the highest law. And to the degree that laws are in conflict with that, the Constitution is not an exception. The Constitution is the highest law. Does that make sense?
Yeah. So it looks like, Todd, when you get into these type of battles, the idea that you have an individual that's really kind of relying probably on more employment law as a protection and really trying to tell a court that the ministerial exception or the idea of the beliefs of a church should not supersede that, it sounds like he may have the whole thing backwards. I mean, that seems like that may be the problem here.
It is. And the example of the Fourth Amendment is a perfect one, right? Because when we talk about the Fourth Amendment, we talk about like there's a car exception or the exigent circumstance exception. So we talk about it in terms of the exception to the constitutional principle. But somehow when it comes to the First Amendment, both the speech clause and the freedom of religion, that seems to be the exemption, right? What I think is important about this case is that this was actually the second time it went up to the Fifth Circuit. It had been dismissed by the district court the first time. It had gotten remanded. They almost took it. They were one short vote of taking what's known as en banc, which means the full Fifth Circuit Court of Appeals. And quite frankly, that's what should have happened. This case should never have gotten as far as it did. You know, someone who represents churches and faiths, like just going through discovery, just going through that process, it's draining of resources. It's hugely expensive. It takes time. It takes effort. You have your administrators being cross-examined on things they should never be cross-examined on. Judges give attorneys great freedom in discovery. I have no doubt in this case that the person bringing this understood the uphill battle, but a lot of times what they really want is just revenge. They just want to get at them, and allowing them to really cross-examine a church on decisions it made is giving the plaintiff, even though they eventually didn't prevail, they have allowed them to do what I think was ultimately the goal here, which was just to harass the people that wronged him in his mind. And people can have that opinion and they can hold that. What they shouldn't be able to do is weaponize a court system against a religion just because they disagree with it or don't like their decision. So I'm glad the Fifth Circuit got this right eventually, but I think that they created way more problems than they should have by their first decision. I also think there was a number of amicus briefs, including the Seventh-day Adventist Church, that came in on the second case. And I think that was one of the things that probably made a difference, is understanding, oh, wait a minute, this panel decision, this first decision was really problematic.
But Andre, I guess the question is, can the church ever be in a position where they ended up firing somebody or disciplining somebody in a way that could be viewed as in violation from a local or federal standpoint? I mean, do they just have carte blanche because it's inside, quote unquote, their own concentric circle, like the Amish operate within their own kind of small community? Are they free to really be able to do whatever makes sense for them? Because it sounds like maybe they have absolute, autonomy here.
Yeah, so the critics say that this creates a lack of accountability, right? That religious organizations could hide behind the First Amendment to avoid legitimate legal consequences. And that isn't a frivolous concern. There are real cases where religious institutions have been held liable for things like fraud and abuse or other conduct that can be evaluated using neutral legal principles. But that's the key distinction here, is that neutral principles versus inherently religious questions. So, and Todd was right. The plaintiff in this case brought claims, a whole list of claims like defamation, employment interference, employment wrongful termination claims, kind of ordinary legal tort claims. But to evaluate them, a court had to dig into questions like, why was this leader removed? What were the theological or ecclesiastical disagreements, and who had the authority within the ministry? And so that's exactly where the First Amendment draws a hard stop. And yeah, the Fifth Circuit got this exactly right. The legal doctrine of church autonomy exists precisely to prevent this kind of entanglement.
I just want us to give like a hypothetical that's not actually so hypothetical, because I think all of you gentlemen have supervised employees before, and we've all supervised employees probably who didn't always get along with their colleagues. But just say you had a colleague that was in like the 99th percentile of jerkiness, who was just consistently rude and abusive to his or her employees, and you've had a couple supervisory conversations where you're like, this just isn't going to fly, like you gotta clean it up, or we're going to have to say goodbye. And the person just is, unrepentant. They just say, no, I'm sorry. This is everybody around here is so soft and we need to get tough and blah, blah, blah. And you say in the end, okay, sorry, you have to go. Now, a person like that, do you think they're going to take it sitting down? Do you think they're going to take it with humility? No, they're going to want to sue you, because that's their personality that got them into the pugilism, that got them into trouble in the workplace in the first place, right? Now we're going to just adjudicate this like an employment dispute at Acme Corp, where we're going to bring in Orlin and Andre and cross-examine them about all of the various ways that this mistreatment of their colleagues might violate Christian doctrine, put courts in the position of saying, well, why is the Adventist Church taking a harder line on corporate, on employee mistreatment than Acme Corp is? And you say, well, because we're Christians and we think that we have to live by the golden rule. And then they say, well, Orlin, are you really applying the golden rule? Do we really want courts adjudicating whether Orlin Johnson following the golden rule perfectly is correct? That's the alternative universe where these constitutional principles are not being applied.
And I just want to echo Tim Schultz. Statutes and practices are subject to the Constitution. The Constitution is not subject to statutes and practices, right? When Chief Justice John Marshall in Marbury, right, since Marbury, when he declared the Judiciary Act of 1789 unconstitutional, he said what Tim just reminded us of, right, which is that the Constitution is the supreme law of the land. And so we have to begin viewing as Tim so nicely put it, these constitutional rights as ultimate rules of recognition. If I could put my jurisprudence hat on, they're the ultimate rules that we've all agreed that we're going to play by, right? And if they are in fact ultimate, then we have to see First Amendment rights as not so much as exceptions, but as the rules themselves.
You know, Orland, this idea just is so fundamental, right? The last time I went to vote, the judges there that were administering the voting process infringed on my First Amendment rights, and absolutely certain about that. And you know, they're talking about their regulations, and they're like, "You got to follow the regulations." I'm like, "How about the First Amendment? Can we follow the First Amendment?" And talk about Kafka S. They were like, "That we don't care about that. That doesn't apply. We have this rule, and you can't violate it." We just have it ingrained in people that the First Amendment just is some kind of exception and doesn't apply. And that's something I wish in society we had a better appreciation of. It's like, if you're going to follow the law, follow all of it. And the First Amendment is part of that. I would also like to say, just pointing out, I do think the Fifth Circuit really got it right. They set up a standard here where if a church autonomy is denied, it's much easier to go to the Court of Appeals now. I think that will be helpful precedent in the future.
Well, I'm going to let that be the last word. And obviously, Todd, I can't imagine a circumstance where you would cause rules to be changed someplace where you went. But I think the idea of really ensuring that individuals who are running religious organizations get to do so in a way that makes sense for them, but also making sure that you keep the balance so that you're not, quote unquote, hiding behind your religion when you're actually engaging in bad acts. Hey, Andre, tell me something I don't know.
Only once in history were two Supreme Court justices sworn in at the same time. Justice Lewis Powell and Justice William Rehnquist were sworn in on January 7, 1972, and in such cases, seniority in the court is determined by age.
Todd, tell me something I don't know.
Should you be a recipient of the Medal of Honor in any of the military branches, there's an unwritten rule that if you're still in the military, they will retire you out. They don't want people serving in the military that have received that award.
Wow, didn't know that. Tim Schultz, tell me something I don't know.
Orland, you can't fully understand American culture and American political culture in particular without understanding the folk ways of professional wrestling. And the modern political figure who clearly understands that best is none other than World Wrestling Entertainment Hall of Famer Donald John Trump.
Tim Golden, tell me something I don't know.
The German philosopher Immanuel Kant, a good Lutheran, good Protestant, part of the pietist movement of the Enlightenment in the 18th century as part of the Prussian Empire, for as good of a Lutheran as he was in his adult life, he never attended church, excoriated Christians for praying, and here lies the greatest irony, perhaps, in the history of Western religion and philosophy. In Kant's adult life, he never attended church, and yet he was buried in the cathedral.
Gentlemen, great being here with you as usual. Thanks again for you being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith in politics. See you next time.